Hi, and welcome to today's episode discussing issues in criminal law. My name is Dale Savage and I'm a criminal defense attorney here in Charleston, South Carolina. And today I'm going to be talking to you about the three most common myths surrounding Miranda warnings. Nearly everyone's heard of Miranda warnings, but most people misunderstand how they're applied or the limitations to them. And that brings us to myth number one. Police must read your Miranda warnings. There's no legal requirement that police have to read your Miranda warnings. You're only entitled to Miranda warnings when you're in custody and being subject to police interrogation. And so what that means is it doesn't even have to be formal arrest, but if it's what they call the functional equivalent to formal arrest, and so that means if you're not free to leave from the police when they're talking to you and they're discussing or questioning you about a crime, then yes, you're entitled to Miranda warnings. However, if you're just voluntarily talking to the police, meaning that you can leave or terminate that conversation at any time you want and walk away from the situation, then they're not required to give you Miranda warnings. And so if you voluntarily confess to a crime or evidence that ends up leading you being charged, then those statements will be admissible against you in a court of law. And that brings us to myth number two. No Miranda, no charges. And that's obviously not true. And most people think that because they haven't been read their Miranda warnings, that they can't be charged with a crime. And the reason why that's not true is Miranda applies only when the violation has occurred. And so what that means is any evidence outside of that violation can be used against you. So if you give a confession to a crime and your Miranda warnings or rights were violated, then yes, that confession can be suppressed and any evidence that's obtained from that illegal violation can also be suppressed. But any evidence outside of that violation, think of fingerprints, video evidence, so if you're committing the crime, eyewitness identifications, DNA at a crime scene, all that can still be ruled admissible against you, and the state can use that to try to get a conviction. And that brings us to myth number three. I can't have invoked my right to a lawyer. It's not enough to say that I wish I had a lawyer or that I'd like to have a lawyer or man, it'd be nice to have a lawyer. You must be clear and unequivocal when invoking your rights. And so what that means is you have to tell the police clearly, I want a lawyer, I do not want to talk to you anymore. If you only tell the police it'd be nice to have a lawyer, I wish I had a lawyer, then police can continue questioning you and any statements that you make as a result of that questioning can be used and will be admissible against you in court. And that also means that you're the one that has to actually invoke those rights. It can't be your parents if you're being questioned by police and they turn up to the police station or in the crime scene and you're being questioned by them. They can't turn around and tell the police to stop talking to you. The police do not have to listen to them in that particular situation. Or if you're at a police station and a lawyer comes representing you and tells them to stop questioning their client, the police do not have to stop questioning you at that point because you're the one that has to invoke those rights. And so that sums up the three most common myths that we have. If you have any questions in your case regarding Miranda warnings or violations, or you think that are violations, please give me a call at 843-530-7813. I hope this video was helpful and thanks for watching.